YouTube, it's Tone back with another one for you, and this one today is a continuation of the Court Survival Guide. Awesome book, great information that I think a lot of people should know, so you know what to expect when you go into this venue. So let's get into it. So strategy 10 is to enter no plea. Okay, so here you are setting yet another trap for the court or judge to fall into, and you will have several options with which to win. You can use either of these options at the time when the judge is demanding that you enter a plea, because they will be demanding that you enter a plea because they fucking need you to get in there, or else they're gonna be left holding the bag because they got some shit in their hand and they're trying to fucking get somebody else to take the blame for it, essentially, because the burden's on them. So they really need you to take that plea. That's why the judge is gonna probably go out of his way to go ahead and enter a plea for you, which he cannot do, but he will try, and if you let him, then he will. So 10A. So you can always start with, but Your Honor, under the rules of this court, am I required to enter a plea before discovery of all the facts? The law states that a plea cannot be required before the rule of discovery is allowed. So when you get a no, their motion for the dismissal on the rule of the corpus delicti, which means that there is no injured party. If the judge denies your motion, then ask for a continuance based on the request for the discovery, because they do need to give you that. They've gotten in the habit of giving everybody the information that led up to the whole situation after the fact, after you plea in, and then you come to find out that the shit wasn't even legit to begin with, but it's too late because you already entered the plea and ultimately granted them the jurisdiction. So then at that point, you'd be at the mercy of them to ask them to let you out of it because you fell into the trap initially. So 10B, the court will always try to enter a plea for you. If you refuse to pick one of their options, how nice are they? Right, because they only give you the options that they want you to pick from. So that's not all the options that you have. They're just giving you the ones that they want you to pick from. You know what I'm saying? So McDonald's doesn't tell you what Burger King is selling. You know what I'm saying? That's all it is. So, and you gamble or prefer that the judge will default you not guilty and try to set a trial date. Good. Here's where you immediately ask, but Your Honor, isn't that practicing law from the bench? Isn't entering a plea my job or my attorney's job? And that's the thing. So they get in the habit of just entering a plea for you. That shit is that's not gonna fly. So you have distracted the judge with these questions now, whatever the answer was, and if the judge has not yet changed your plea to not guilty, then quickly ask, so are you making a judicial determination? If no, then the judge is now caught in a contradiction of error, which you can detect, follow up on, and ask for a resolution, but a no is unlikely because they don't like to admit having made an error, as if they're not human. You know, everybody's human. You make a fucking mistake and, admit to it and move on. So if the judge then says yes to the above question, then you say your thanks and leave. You have won. You will then turn around the next day and file a notice of default, holding the court to its judicial determination that you are not guilty. The court in this case has made a technical mistake, because if the court enters your plea of not guilty, then it has ruled that you really are not guilty, regardless of its decision to continue the case against you. You win. So the right sentence, you already have that initially on the record, because all this has to be on the record too, mind you. So 10C, if the judge enters a plea for you of no contest, which is more likely, then you could protest that the judge is unfair because you do not understand the nature of the charges, nor have you decided whether to contest the charges. You must also protest that the ruling is not acceptable because the court will treat you with your no contest as if you were guilty, and that's the thing. So point out that you demand the court to comply with the law, which guarantees that you are innocent until proven guilty. All this because you want the judge to enter a no plea as a plea of not guilty. Stick to it. If necessary, point out that the court is deliberately constraining you to unfair plea choices and that it has no right to constrain you. Not to worry, you can always change your plea before the trial. So even with the no contest, you will then turn around the next day and file a notice of special appearance to change your plea and outmaneuver the court. So these are some pretty good little options, I think. That'll put you in a pretty good position to win. You know what I mean? So 10D, another elegant option is to simply not enter any plea and silently let the judge enter a plea that he or she wants, but without giving you the permission to do so, which they really get in the habit of. I mean, this shit's crazy. If you ever sit in a fucking courtroom and watch what these people do, this shit is ridiculous. So they are not really doing you any favors. In fact, this is just satisfying a phony court requirement to con you out of your rights. You could then silently go home, turn around the next day, and file a notice of demand and a motion to dismiss the case because of judicial misconduct. Because you have not given the judge your power of attorney to enter a plea on your behalf, he or she is illegally practicing law from the bench and defrauding you out of your power of attorney. And if the judge then ignores and overrules your motion, you have now legal grounds for recusing or dismissing the judge before the trial. So strategy 11, plead confusion, which is a no plea. You can also use this strategy whenever the judge is asking you to enter a plea and whenever the judge asks you if you... Let's see what we got. Oh, the judge enter a no plea. So that's not it. Then I put those pages in there twice. So there we go. So if you do not understand the charges, so here you are setting another trap by exercising your Sixth Amendment right to be informed of the nature of the charges. If you don't understand the charges, then the court cannot legally continue the case against you. So if the judge asks you if you understand the charge, you say no, then you can then get right you can then get right into asking more questions relating to the contradiction that you already see with the case as it is being presented to you. And everything has to be on the record too. Just always keep that in mind, that you just keep specifying that is this on the record or for the record. So if you appear too confused to enter a plea, or if the judge believes you don't understand the charges, you can easily get the standard speech about getting a licensed attorney. The judge may even give you more time to consider getting one. You can even change your mind about how to defend yourself. In addition to one of the above strategies, you might even corner the judge with his or her own speech. If the judge becomes impatient or irritable enough with you about your non-compliance with his or her directions, he or she may actually threaten or command you to get an attorney. This is the perfect time to ask, has the court made a judicial determination that I do not have the right to represent myself? You see, this puts their fraud right on the record, and the judge will have to either dismiss the case or retract the threat or command. If there are any such contradictions left unanswered by the judge, be sure to ask why. So then if the judge insists on entering your plea, making a decision for you, you can then turn around the next day and file a notice of demand and a notice of dismissal because the judicial misconduct. Because the judge has acted upon your defense without properly written and signed power of attorney, i.e. your permission, there are so many ways they are cheating, it's hard to believe that they can still get away with this shit. So strategy 12, special appearance. This is a court appearance that is not required by the court itself. You must file the request yourself because you had special appearance. So this is a court appearance that is not required by the court itself. You must file the request yourself because you have a specific reason for doing so, such as a change of plea or a change of status. Special appearance or special visitation may occur anytime up until the trial. So this is especially good for delaying your whole case with an additional hearing to address issues which must be resolved. If the judge has refused to file and process your notice of special visitation and of foreign law and your judicial notice of military flag and challenge of jurisdiction, then now is a good time to file these notices by certified or registered mail, thereby forcing the court to respond and schedule a special hearing date. When you're dealing with the courts with shit like this, definitely send that shit registered mail. They'll send that shit with an armed guard directly to these people so they can't pretend that they never got the shit. So if you wish to make a formal reservation of rights using the special appearances hearing, then you can follow up the example given in the appendix. Whatever notice and demand paperwork you serve upon the courts you must also serve upon the prosecutor. Make sure that they receive their copies well ahead of anything else scheduled for your case so that the court has time to reschedule if necessary. second court appearance in the plea bargaining. With any skill and any luck at all, you will no longer have to appear by virtue of having won the arraignment by dismissal, so this section applies to cases which have slipped through the cracks or have already got past you. So the purpose. This usually follows the initial arraignment right away because you have pleaded not guilty. The court is graciously providing you yet another opportunity to change your mind, plead guilty, and pay up. They will try to bargain some of the penalties in exchange for your guilt and obedience. Beyond getting you to submit to fear, fraud, and control, there is no other purpose. So your purpose by this time is to minimize your liabilities, your fines, and or create more opportunities for the judge to dismiss your case. What to expect? They will probably even offer to reduce the charges against you, thereby reducing your fines if you will only bend over and submit to the system. They may even graduate you to facing the district attorney in place of the deputy district attorney in a flagrant attempt to intimidate you. This is not such a bad deal, other than losing the game, because the court has given you the chance to lower your fines. They are acknowledging that you are not going to be completely taken advantage of by their fraudulent system. They are aware that you know something about your rights, and they are prepared to collect less money from you than they had originally tried to get away with. But rest assured, they know exactly how much they will get from you, even with the reduced charges, and it will be more than the court has invested in convicting you, because they're a money-making business. So if the shit don't add up, they're gonna just drop the case because they're not gonna make money. So if it costs you more money than you're making to make the money, then you're not really profitable, and it doesn't work that way. So, it just comes down, and I mean, you gotta pick your battles too, because I mean, if it costs you more time out of your life than just telling them to send you the bill or some shit, you can just discharge the bill anyway. If it's about fines or whatever shit like that, I mean, you're gonna waste fucking three months arguing in court. Are you just gonna say, you know what, just give me the fine, send that shit to the IRS, criminal investigations, and let them handle that shit? So what to do? So if you hold to your plea of not guilty, they will try to assign you a trial date as quickly as possible without giving you a chance to contest any of the procedure rules or options. What to do? Generally, you want to take advantage of your knowledge and preparation to expose the judge and or prosecutor's fraud. Using some of the strategies listed in the previous sections, you must focus on concerning the judge with your legitimate questions to get the case dismissed. You will have fewer options now because you have already allowed the jurisdiction over you from the previous arraignment hearing. Keep in mind that you can possibly let the case go to trial, but it will be much harder to win there because of the ways that the trial and jury are rigged. So it is better to win the game before trial. Because you got to be a pretty good actor in trial in order to win. Even if you're not guilty, you got to fucking learn how to act not guilty. How do you act not guilty? You know what I'm saying? So anyway, strategy 1. Repeat a strategy from the previous section, such as refusing to acknowledge the plaintiff or challenging jurisdiction, etc. Strategy 2. Demand a motions hearing. This is one of the best ways to buy more time so that you can maximize your opportunities to win the case before trial. Before the judge gets around to setting a trial date, demand to instead have a motion hearing. The judge will probably look surprised that you even know about this and may attempt to discourage you. Just explain that you wish to exercise your pro per right to present several motions relating to critical issues relevant to and directly affecting your case. You must resolve some pivotal and key legal issues in your case in order to continue. You will need to type up your motions and send them to the court and prosecutor ahead of time, as described in the next section. Strategy 3: motion for discovery. This is to force the court to place in evidence every last bit of information, including unrevealed government contracts such as the driver's license that the prosecutor is using against you, etc. So strategy 4: general. Review the available strategies from your first appearance, arraignment. Pick out one or more that will still apply to your situation. Use any technique you can to find to embarrass the judge into dismissing the case. Motion for dismissal at every available opportunity. And get all that shit on the record. Every single motion you make, every action that's taking place. Make sure that it's verbalized, that it's articulated well and verbalized for the transcriptionist to be able to get it all down. But you got to bring your own there, court reporter. So strategy 5: motion to withdraw your plea. This is a slick trick to temporarily remove your implied consent to the court's jurisdiction. By vacating your plea of not guilty, technically the venue and jurisdiction is removed. So here is where you can again use the notice of special visitation and of foreign law and the judicial notice of military flag and challenge of jurisdiction. See appendix. Make sure the court agrees to vacate your previous plea before you say anything more. Before you are required to enter a new plea, present these two notices and demand the resolution of jurisdiction. Now the court will now be up against the wall because it must stop everything and make a legal determination as to whether the court even has jurisdiction, because it no longer has your plea. It no longer has your consent to their implied and assumed jurisdiction. So now I have to start back over, and they have to refine the facts about the validity or even existence of their jurisdiction in general. So immediately, motion for a dismissal for lack of jurisdiction as soon as they and this is going to really put them in a tough position actually. Immediately, motion for dismissal of lack of jurisdiction because they don't have it. They don't have your plea, so you're trying to just get out of that right there. So they don't have your plea. It starts back over. They need to re-get your plea to get your consent. They don't even have it anymore. Immediately at that point, motion for a dismissal for lack of jurisdiction because they don't have it, and you already know that. And as soon as they try to dance around it, if the judge doesn't dismiss the case now, then object or recuse him or dismiss the judge for obvious bias against you and place him or her on notice of your intent to appeal his or her judicial error. This is their mistake for sure. Strategy 6. Bargain your plea. This is a strategy to use only if you have changed your mind about standing up for your rights and or you find that being in court is just too stressful to deal with. The best news is that although you must change your plea to guilty, at least you have reduced and minimized your fines and you have terminated the game so that you will no longer have to be in court. You have settled for a partial win. So cutting ties, cutting your losses, I guess you could say. So strategy 7, reserve your rights. This is what you should do when it looks like they're just going to roll over, like they're just going to roll over you and continue with the case against you. So regardless of your motion to dismiss, based on the other strategies that you have tried, now make sure that the court recorder is on and you can make a speech similar to, Your Honor, I'm sorry to take up so much of your valuable time, but I still do not understand the nature of the law being charged against me. You have either refused or denied that this court is of common law, equity, or admiralty, so by now you must have made a judicial determination that the court is operating under Article 1, Section 8, Clause 17 of the Constitution, which just means that they can regulate commerce. Therefore, you must be sitting ministerially and not judicially, and that is actually the corporate state of XYZ, which is bringing this case against me. And since the state of XYZ discharges its debts with negotiable instruments instead of gold and silver, then this court must therefore be operating under the negotiable laws codified into the Uniform Commercial Code. Further, this means that there must exist a contract, and my obligation to that contract must comprise the statutes brought against me. Are these determinations correct? If no, then ask which are correct and which are not correct. If yes, then thank the judge for clarifying your understanding and then make a formal notice of reservation of rights under UCC 1-207, which is now UCC 1-308. I reserve the following rights. Then just list all of the rights you want to reserve. Then demand the court to place in evidence all such contracts mentioned above. The judge may fake ignorance and then ask what you mean by the UCC reservations. This is an attempt to deny your rights. This is an attempt to deny your rights. Right, so followed by its own judicial order with just the letterhead and space for the judge to write and sign. Be sure to include your case number. Get out your PC or reader machine and crank out the motions. Here are a few ideas. So what do we got here? Yeah, so this is apparently this shit is the first page that was supposed. So this is the last slide, but it's supposed to be the first page, and I'm not fixing this shit, so check it out. So this is the beginning. So how's that for Back to the Future? So followed by its own judicial order with just the letterhead and space for the judge to write. Be sure to include the case number. Get out your PC or reader machine and crank out the motions. Here are a few ideas. So strategy 0, default again. If the officer doesn't show up, or if it has already been 6 months since your citation was issued, then you win by default. So there's a statute of limitations there too with the tickets that they write. So they have a 6 months statute of limitations, it looks like. So you already win by default if it's over 6 months. So you can probably get it dismissed if you file a motion to dismiss based on the statute of limitations. You could probably just win just based on that. So challenge the jurisdiction using previous strategies. Reserve your rights. Strategy 3. Challenge the ticket. Use this. If you haven't already done so in your previous appearance, motion to dismiss as a first priority to take formal advantage of any possible error written onto the ticket. So, but only if you know that there is some technical error in the way the ticket is filled out. As to compare with the original copy, for instance, something will be spelled wrong. A number could just be 1 digit different. Time, date could be wrong. You may have written something onto it that renders the ticket null and void. So, which I mean, you may have too. So, I mean, if you reject the ticket or things like that, ultimately the ticket is void at that point. So you could bring up the fact that it is no longer void because it has been rejected and things like that. A lot of different avenues that you could take, and the more that you know, the better your opportunity of getting out of there fucking alive is. You know what I'm saying? So there's that. What was I gonna say? Yes, you already know, man. The more you know. Awesome information here. You guys already know. If you have any questions, email me, sovereignproduction369@gmail.com. It is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.